Script is written 880 words, within the 900-word target range. One note: I searched for a real documented case matching Ballistics report rediscovered in 2022 and didn't find one that fit cleanly. The closest real analog, Patrick Pursley's Illinois firearms ID exoneration, has a different timeline and specifics. Rather than bolt fabricated damning details onto a real, identifiable person's actual criminal case, I wrote this one as a composite case, fictional names county in the exact house style, same specificity, same beats, same rhythm, flagging that since the profile calls for always a real named case. Here's the script. They convicted Dwayne Kessler of murder in 1996. The jury took 4 hours. He got life without parole. Then, in the spring of 2022, a records clerk clearing out a condemned annex in the county courthouse found a sealed manila envelope wedged behind a filing cabinet. The original ballistics report from the case, the one that was never entered into evidence. And it didn't match the gun the state told the jury killed Ray Talbot. So why does the document that should have opened this case not appear anywhere in the trial record that closed it? The official story was simple, and for 26 years, nobody had reason to doubt it. On the night of November 3, 1995, Ray Talbot was shot once outside a strip mall laundromat in Grayson County. Police recovered a single .38 caliber shell casing at the scene. 3 days later, they arrested Dwayne Kessler, a 22-year-old with a prior weapons charge, after a confidential informant said Kessler had bragged about the shooting at a pool hall. Detective Earl Vance testified that a .38 revolver recovered from Kessler's apartment was consistent with the fatal wound. The prosecution's firearms expert, a state crime lab technician named Roy Deal, told the jury under oath that the casing could not be excluded as having been fired from that weapon. No written ballistics report was ever produced at trial. Deal testified from memory and from handwritten notes. The jury believed him. The envelope the clerk found in 2022 was the actual lab report, typed and signed, dated November 19, 1995, 6 weeks before the trial began. It ran 4 pages. Page 2 contained the microscopic comparison findings. And on page 2, in Roy Deal's own handwriting next to the section marked conclusion, was a single word: exclude. The land and groove pattern on the recovered shell casing did not match the barrel of Kessler's revolver. Not inconclusive. Not consistent with. Excluded, the forensic term for a gun that is ruled out, not implicated. The report even noted a secondary detail. The firing pin impression suggested a semi-automatic pistol, a mechanism Kessler's revolver couldn't produce at all. This was not a gray area. This was the one document capable of ending the case in December of 1995, and it never left the lab. Here is the contradiction the verdict cannot survive. At trial, Deal swore under oath that the casing could not be excluded from Kessler's weapon, the near opposite of what his own signed report said 6 weeks earlier. Defense counsel never received the report in discovery, despite a standing request for all forensic materials related to ballistics comparison, filed October 1995. The prosecutor's file, later reviewed by the Grayson County Public Defender's Office, contained a discovery log listing 11 items turned over to the defense. The ballistics report was not among them. Either it was withheld, or it was misplaced before trial, and Deal testified from memory alone, memory that happened to align with the state's theory instead of his own written conclusion. Why did this never surface for 26 years? Because the Grayson County Crime Lab at the time operated under an arrangement almost nobody outside the department knew existed. Physical evidence and lab paperwork were stored separately, in 2 different buildings, under 2 different retention schedules. Ballistics reports went to the lab's internal archive, a room accessible only to lab staff, never audited by the district attorney's office and never subject to a defense subpoena, because defense attorneys didn't know the room existed. Roy Deal retired in 2001. The lab was absorbed into a regional forensic center in 2004, and the internal archive was slated for digitization, a project that stalled for budget reasons for 18 years, until a court order in an unrelated case forced the county to finally empty the annex in 2022. But the ballistics report wasn't the only thing in that envelope. Paperclipped to the back page was a one-line interoffice memo, dated 3 days after the report, addressed to Detective Vance. Per our conversation proceeding as discussed. No further explanation. No record of what "as discussed" meant. Investigators who reviewed the file in 2023 couldn't find any other note referencing a conversation between Deal and Vance about the ballistics findings. Nothing in Vance's own case log. Nothing in the prosecutor's notes. A single sentence, unexplained, sitting on top of a report that excluded the defendant's gun. If the report had reached the jury in 1996, there may have been no conviction at all. Detective Vance died in 2009. Roy Deal, reached by Kessler's post-conviction attorneys in 2023, said he didn't recall the memo or writing it. The Grayson County District Attorney's Office, which secured the original conviction and has handled Kessler's appeal since the report surfaced, has not explained why an internal archive existed that neither prosecutors nor defense could ever access. Only that policies have since changed. Dwayne Kessler's case remains under review. The ballistics report has been entered into the court file for the first time in its existence, but the interoffice memo, 6 words, an unnamed conversation, a decision made and never written down, still has no explanation. Nobody has said who Deal was talking to, or what exactly they agreed to proceed with. Saved to home/jarvisadmin/script ballistics report 2022 txt.